My PowerPoint this morning is very basic. My title is IRD Basics. But first of all, I want to thank all of you for being here. Gosh, it's such a full house, and it's really a pleasure for me. I've been a member of the group, and pardon me, I'm a walker. I don't sit still, so I got a cordless mic, so I have no restrictions. But I want to thank all of you for being here. I think I've been a member of the group for about a decade, and it's amazing how many of you that I know, have worked with, have heard speak, and so it's finally my turn to be on the stage here. And maybe I need to sit still because they're filming us in the background. You might have a hard time following. So I like to build in a lot of time for questions from the audience. So if you have a question during the presentation at any time, don't hesitate to raise your hand, because you probably have the same question as someone sitting right next to you. So if we get your question answered, we can move on to the next topic. So today we're going to talk about IRD, and I'll explain what the heck IRD is. I apologize for yet another acronym. They're kind of run rampant in the plan giving world, the legal world, and the financial world. And we're going to talk a little bit about best practices when working with these types of assets as gifts from donors, kind of some best practices you can keep in mind. And we're going to talk a little bit at the end about some legislation. I think that might be on someone's mind here. There have been some changes in legislation around these kind of assets and some proposed legislation as well. All right, simple agenda. We're going to talk about a little bit of background so that you have kind of some terms and basic definitions in your head before we move on. We're going to talk about the opportunity around these kind of assets, and I think you'll be astounded at what opportunity there is out there with this type of an asset and how we really need to be focusing on it for giving, plan giving, and just straight out giving. We're going to talk about some rules, unfortunately. I mean, I am an attorney. I do work in the financial services world, so we do have to talk about rules. I know a lot of you just want to cringe when we talk about, the tax code and things like that, but that's where this stuff comes from. Our opportunities for tax advantage giving come from the tax code. So let's just embrace it. Let's just be okay about it. And then we'll talk about some best practices at the end. Okay, so we may not take the full time if we don't have a lot of questions, but continue to eat. But if you have questions, just flag me down. All right. First of all, what is income in respect of deceased? That's what IRD stands for. And to paraphrase the tax code, it's basically income earned but not yet received into your pocket before death. Some types of assets are retirement plan balances, which we're going to cover today. The whole list of things that are actually IRD. Uncollected wages, uncollected rent. So say you were a landlord. You had some rental property, and those people had owed you rent, but you hadn't collected it before you died. That's IRD. So in the case of a retirement plan balance, let's say you had $500,000 in an IRA. It's never been taxed. You pass away, but you didn't collect it because it's held in the account. That's IRD, okay? Income in respect of deceased. So the only reason it becomes income is because that person has died. All right? Pretty basic, right? We're going to focus on the retirement plan accounts today. Now let's look at the opportunity. Almost $25 trillion sits in people's retirement accounts right now, just in this country. $25 trillion. Did anyone have any idea the number was that big? I didn't when I started doing this research. It's a huge amount of money, huge amount of money. The opportunity also arises because this is a simple and flexible way for people to give. It is probably one of the simplest and most effective ways someone can make a gift to charity that benefits not only you, but them and their heirs. Now I'm just going to talk about basics. Our speakers in the second half of the program today are going to talk about some more kind of complicated ways you can use these assets to benefit your heirs and or family. So we're just going to talk about some basics here. But simplicity. It can be just as simple as naming a charity as a beneficiary on a form. Filling out a form. You don't have to go to an attorney to do that. Usually a financial advisor can help you. In a lot of cases, you can do it online or with a simple form faxed into your bank. It's very, very easy. It's also very easy for the donor to change their mind, right? So this is a revocable gift. You sign on the dotted line and say, I want my IRA to go to the University of Minnesota when I pass away. 10 years go by. Say your IRA changes hands. It goes from one administrator to another. Let's say you got a new financial advisor, so you move your asset from Wells Fargo to U.S. Bank. You have to redo your beneficiary designation to the University of Minnesota. If you're not aware of that, and you don't do your beneficiary designation for the U of M, maybe you don't even fill one out. Does anybody know what happens when you don't fill out a beneficiary designation form for your account? Where does it go? Your estate. And it goes into your will or your trust, and it may not even get to the U of M. So it's very easy for someone to name you as the beneficiary, but it's also very easy for someone to intentionally or unintentionally unname you. So we want to make sure that we keep the lines of communication open with our donors with these revocable gifts. They're very vulnerable to changes, whether it's intentional or unintentional. We just want to make sure that we keep that donor engaged. We'll talk a little bit more about that later. Now let's talk a little bit about tax advantage. If these assets have never been taxed, like I said, you have $500,000 sitting in an IRA, it's never been taxed, and I tax away, it's taxable to whoever receives it, my heirs, right? But if a charity receives it, the income tax evaporates. No one ever pays it. So it's a very advantageous gift for you, the charity, obviously you're not paying taxes, and it's also advantageous for the donor and their heirs because they're not receiving an asset that has a buildup of a potential large tax bill. So with some creative planning, those assets are great to give to charity because, again, the income tax evaporates. So if they don't need all that money during their retirement or their heirs aren't going to need it, it's a great asset to give to charity. So, any questions on that so far before we move on? These are just the basics. And a lot of this is probably basic to a lot of you. Yeah, question?
Is there a tax break for giving IRA?
There's not a tax break because you never pay tax on it. You can't get a tax break unless there's actually a tax to be paid. So in that case, there are no tax breaks, but you never got taxed on it in the first place. So it's kind of the same thing. Make sense? Yeah. Other questions? Nope, that's a good one. I know this is kind of small. I'll do a little bit of. Oh, we got questions. Yeah.
Sorry, I'm very new to all this.
No, that's all right. I'm sure there's a lot of new people.
If it's beneficiary to make a family, but they decide to give it to charity, like with that.
So the situation is, I am the parent, you are the child. I name you as beneficiary on my retirement account, and you take the money. And then you decide to give some or all of it to charity. What are the consequences? Well, you received the money, didn't you? So you're taxed on it. So you have to recognize that tax. Now, in the same tax year, if you went and took that money and gave it to charity, there could be a deduction there that could offset some or all of that depending on how big your inheritance was and how big the gift was. But still, when you take possession of something, it becomes yours, you have control over it, that's when that tax is recognizable. So, good question. Okay. Others? Good. Love it. All right, let's get back to the opportunity. This is smaller on the screen than I had expected, but this is U.S. total retirement market up until 2015. The number up here is $24.9 trillion. That's how much money is sitting in retirement accounts. And this is a mixture of things like annuities, IRAs, 401ks, 403bs, other qualified retirement plans. I mean, that's a lot of money. Back in 2000, it was 11.6. At the downturn in the economy, we had about 14.2 trillion, that's T. And the number keeps rising through investment performance and contributions. By and large, Americans have been very, very good at contributing to their retirement plans. Not only their money, but maybe employer matches, things like that. Okay? So there's a lot of money sitting in there. There's a lot of pent-up tax revenue sitting in there. So with some really good creative planning, this can be an incredible opportunity for your organization. There's a lot of money sitting there on the table. Now, if the donor takes it out, they pay tax on it. If their heirs receive it, they pay tax on it. Possibly, you could pay even estate tax on it, if your estate is large enough. And here in Minnesota, it's not all that hard to get up to that nearly 2 million is what we're approaching as far as our estate tax exemption. So there's a big opportunity here, okay? So let's talk about some rules. Method of transfer. one really crass saying I have is dead people can't own stuff. So there's a couple ways to transfer their assets when they pass away. You know, it's really crass, but it makes sense to people. So there's a few ways to do that. You can do it through beneficiary designation. So if you have an account, like a bank account or an IRA or a 401k, you can transfer that by signing on the dotted line. I want it to go to my heirs, or I want it to go to my favorite charities. Now, not all assets can be passed by beneficiary designation, only certain ones. Usually financial type accounts can pass by beneficiary designation. And then there's something called probate. Okay? Now, retirement accounts don't go through probate because they have the beneficiary designation. So let's just talk a little bit about probate, because I know it scares the bejesus out of a lot of people, and they think, oh, probate is the worst thing since, you know, the meteor that killed the dinosaurs. Probate is just a process. Because dead people can't own stuff, they have stuff when they die, we just have to transfer it to the living people, to the charities, to the existing entities. So how do we make sure that's done properly? Okay? If they have a will, we take the will to the probate court and we say, okay, your probate court, these are the instructions that our deceased person gave to us. And the court administers that process to make sure that those assets are transferred properly and that their debts are paid. It's just a process to transfer assets, okay? Now, if they died with a will, those are the instructions. What if they died without a will? State law decides where that money goes. Does any of it go to charity? No, never. Debts are paid, taxes are paid, next of kin gets assets. So again, when you're meeting with your donors, it's really important for you to, again, encourage them. Not all your assets are going to pass by beneficiary designation. You have other things that you want to take care of. It's very important for you to have a will or a trust, some sort of instruction. But that's all probate is. So if you have an asset, an IRD asset, like a retirement account, it doesn't go through probate. You just sign on the dotted line. Now we know that when someone names you as a beneficiary in their will, they're very unlikely to change that, right? If you've read any statistics on giving through wills and trusts, people are very unlikely to change that. But earlier we talked about that beneficiary designation is very easy to change or just kind of evaporate if that account changes administrators and goes from one bank to another. So again, that brings us back to engaging the donor is very, very important. We want to make sure that we do that and remind them why they made those gifts. Questions? Methods of transfer. We've got about 2 here. Yeah?
Would it be better to just have, to teach people to use the estate to disperse things rather than worry about individual investments as a beneficiary?
So you're saying,
Like the, for my investment, rather than being beneficiary on the bank,
Mhm.
instead put it to the estate.
Mhm.
And let the estate do all that.
that's true.
And then it's just one thing.
It is, and the question is, wouldn't it just be easier to name your estate as the beneficiary of all of your retirement assets, all of your IRD assets? You know, name your estate as the beneficiary. It's a matter of preference, and sometimes it's a matter of tax planning, sometimes it's a matter of efficiency. You know, transferring assets by beneficiary designation oftentimes is a lot quicker. It doesn't go through the estate. It doesn't have to pass through the probate process or the trust administration process, which can increase fees, administration fees. So it's a matter of preference, and I think it's a matter of planning what you're really trying to accomplish. I don't really have time to go into all the details of that, but some people will do that. They'll just name the estate as the beneficiary of everything. In our next speaker's content, they'll get into a little bit more of that. So, all right, but that's a really great question. All right, who pays the tax on these assets? So the general rule, and we got to this with Sherry's question earlier of who pays the tax and when you receive it, you pay the tax. Okay? So in your example, let's say you name the estate as the beneficiary. Asset goes into the estate's responsible for the income tax to an extent. Okay? A trust. Maybe you name a trust as the beneficiary. The trust is responsible for those taxes. There could be some offsetting deductions to reduce that. We won't get into that today because of time. But I just want you to understand whoever receives it is responsible for the tax. Whether it's the estate, the trust, the individual that takes possession of those assets. Now there's the charity. We know the charities are tax exempt. Most of the time they're not paying income tax. Except in Pennsylvania, there's some weird stuff out there, but we're not in Pennsylvania. But charities generally aren't paying income tax, okay? So the charity takes possession of the assets, income tax evaporates, and we get back to our amazing charitable planning opportunity, okay? Now, this is probably the most important rule I want you to remember from today. It's a term, designated beneficiary. Has anyone ever heard this term thrown around? Okay, we got a few in the audience. Why do we care? I'll tell you why we care in a minute. A designated beneficiary is someone, a person, a natural person, who is named as the beneficiary of one of these IRD assets, let's say a retirement account, at the time of someone's death. They're still a beneficiary on September 30th of the year following death. Really important. It sounds very strange, but this is the definition. And they're also not a shared beneficiary with another non-entity. Okay, so again, there's a lot of negatives to define this, but it's a natural person named as beneficiary. They're still a beneficiary on September 30th of the year following death, and they're not a shared beneficiary with another non-individual. Okay, great, that's fine. Why do we care? The reason is, let's say I have been named as the beneficiary of my mother's IRA. She also named a partial beneficiary, her church. I'm not a designated beneficiary because I'm a beneficiary with a non-person, non-individual. Fine, why do we care? We care because the ways that I can take those assets out of the account are limited if I'm not a designated beneficiary. So individuals want to be designated beneficiaries so they have the full range of distribution options from that account. We're going to go through those distribution options. Okay? There's a way to get around this so that you can name both family and charity as beneficiaries, and we'll go through that. But just remember this designated beneficiary is an important term, something you need to remember. So if you are a designated beneficiary, you get all the options. So let's just go through the options, and if someone has a question about these, please let me know. These can be a little tricky, a little weird, a little confusing. So obviously you can say, hip hip hooray, I just inherited $500,000 from my mother's IRA. I want the whole check right now. Write me a check. Oftentimes that is really attractive to people. It's my money, I want it now. You've seen the commercial? It's kind of like that. It's my money, I want it now. It comes with a lot of income tax. And depending on your other income and the size of the account, I mean, you could be paying quite a bit in federal and state income tax if you take that lump sum, but it's pretty attractive sometimes to people who aren't really thinking of planning. The next is 5 years. You can take it all out within 5 years, by December 31st of the 5th year following death. You don't have to take anything, not 1 cent, until that December 31st of the 5th year, if you choose that option. Sometimes attractive for people who are maybe making a good income. They don't want to take a lot of income into their life now, so they just say, you know, I'll take it out within 5 years. That's what I'll do. That's the choice that I'll make. That 5-year anniversary rolls around, they got to take the entire thing out if they haven't taken some already. Okay, so that's option 2. The third option is probably the most attractive to people who are doing some income tax planning, is the lifetime option, or the RMD, the required minimum distribution. You've probably heard that term, the RMD method. So if I inherited my mother's IRA, and let's say I'm 40 years old, I'm going to start taking distributions based on my life expectancy. It's a formula you figure out. What's my life expectancy? What's the value of the account? Let's divide it up. I take distributions over my lifetime in smaller increments. And that's relatively new. That wasn't always available to non-spouses. So this is something that people are liking these days. So no matter who inherits it, individuals, they can take that lifetime. Which is good for tax planning. You want to spread it out over time, and it continues to grow tax deferred. So that's nice. Another option, not usually a very attractive option, is to disclaim. Say, I don't need it, I don't want it. Let it go to the contingent beneficiary, or let it go to the estate. I don't need it, I don't want that $500,000. I just won the lottery, so whatever, my siblings can have it. It's not very popular. There's a right way to do a disclaimer, and then there's a wrong way to do it. I don't have time to go into the right way to do it, but that is an option. So that's the fourth option. Any questions about those options? Yeah?
On the lifetime distribution, must you set it at the minimum distribution, or can you,
You can take it out faster. IRS loves that.
okay, and if you choose the minimum, can you later on say, now I want the whole lump?
Yeah.
Where's that, I'll take it right now.
You can always take it faster, you just can't take it any slower. Because the whole thing is we want to generate that tax revenue, so we want that money coming out. That's why that lifetime distribution wasn't always available. You know, but that lifetime distribution, it spreads out or it delays that tax revenue. Okay?
So that you could conceivably take out a smaller payment until you retire and then accelerate your payment.
You could, yeah, you can take it faster, you just can't take it any slower than the option you choose. Ooh, we got lots of questions. All right, back in the corner.
How does this work if there are two natural persons who are co-designated beneficiaries?
They can usually take separate accounts. They'll take their share, and it goes into what's called an inherited IRA. And I'm just talking about IRAs here. I'm not talking about 401ks. We won't get into that right now. But generally, the rules are the same. But they'll take separate, and then they'll take it according to their own life expectancies. Yeah, generally. Yeah, right here.
I just want to clarify on the earlier question.
Yep.
Naming an estate, naming a non-person, so we use options.
I think I'm going to let the next speaker get into that because it gets into some weeds here, but I do appreciate that. Yeah, the question was building on the earlier question about naming the estate as the beneficiary. It's a non-entity. How does that work? It's pretty complicated. So we'll let the next speakers address that as deeply as they plan to. We had a question back here.
If someone takes a lump sum, is the tax paid at the decedent's tax rate or the
Great question. So again, we get back to my example. I inherited $500,000 from my mother. I'm working as a neurosurgeon. I'm already in the top tax bracket, state and federal. I take that $500,000, I'm paying it at my tax bracket. It's at the recipient's tax bracket. So very good question. Thank you for bringing that up. Yep, Dave.
What is the potential duration of the lifetime option? Can it just keep, you inherit your $500,000, you elect the lifetime option, you pass away and there's still $400,000 in the account.
Yeah, it has to keep paying out on, in that case, when you have a second generation. So the question is, what if I give it to Dave? Dave takes it out over his life expectancy, and then Dave passes away before he takes it all out and passes it to his kids.
Right.
It has to keep going on your life expectancy schedule as a second generation inherited IRA. So it can't just go on and on forever. Yeah. But normally what happens is that the distributions have kind of a bell curve. They'll start small, they'll peak, and then they'll start getting smaller and smaller as you get into your elderly years. We had one more question here.
If an individual picked 5 years and then at year 4.5 realizes they haven't taken all the distributions and they don't want to, could they at that time change the remainder to a lifetime? Okay.
No, you got to decide up front, and that decision is very important for that exact reason. You can't change your mind later. They want you to decide what you want to do. So you got to take it all out if you chose that 5 year. Okay. Good questions. Any others before we go on? Okay, good. Now, spousal options. Surviving spouses have a couple more options. And we kind of expect that because couples do planning together. We want to make sure that we encourage that. So spouses have some extra options. So let's say that I'm a surviving spouse. I didn't inherit the IRA from my mother. I inherited it from my spouse. So I have a couple options. I can take that account, that $500,000 account from my spouse, I can roll it into my own IRA and treat it as my own, and then I will take it based on my life expectancy. When I turn 70 and a half and I have to start taking RMDs, that'll be included. It'll all be like my own. And that's exclusive to spouses. So in the case of my mother, let's say she's 85 and she gives it to me, I can't roll it into my account and delay the payments. Okay? It's only for surviving spouses. So my spouse passes away, leaves me that $500,000 IRA. I have the option to roll it into my own, and if I'm considerably younger, that might be an advantage to let me spread that distribution out over my life expectancy. Okay, this doesn't make a whole lot of difference if it's a charitable beneficiary, but I think in the whole planning process, it's good for you to have this in mind. It's good for you to be mindful of these things, so that when you're having a conversation with the donor or their CPA or their attorney or their financial advisor, you have some knowledge about this. You can have an intelligent conversation with them. Now, the other option is if the deceased died before their 70 and a half birthday, the surviving spouse can delay, they can put it in an inherited IRA, not their own, and they can delay those payments until the deceased would have turned 70 and a half. Okay? So let's say I'm a lot older than my spouse. I don't want to take those distributions. I put it in an inherited IRA and I take the distributions when my spouse would have turned 70 and a half. So if you've got a big age difference and the younger spouse died first, that might be the option you choose. So depending on ages, depending on tax planning, depending on a lot of different things, people will take one of these options. But it's good that people understand what their options are. Now, if they name the charity as 100% beneficiary, no one has to worry about any of this. But as you can see, it can be a little bit complicated for figuring this out. Not just because of the rules, but for family dynamics. You know, one child wants one thing, one child wants another thing. Trying to figure out the dynamics of that. Any questions? Yep, question.
With your non-spouse beneficiary, don't they also roll it into their own inherited IRA, or do they just leave it in, like in your case, the parents'
Yeah.
IRA?
So are you talking about the spouse or the non-spouse?
Non-spouse. And so you use the illustration of your parents and yourself.
Yep.
So would you roll it into your own inherited IRA?
Yes, we put it in an inherited IRA. So if I got it from my mother, it would be the, the Roberta Holt IRA, inherited IRA for the benefit of Dana Holt. That's what it's going to look like. So it's going to go into an inherited IRA. That's just the name of the type of account. And you can't commingle it with your other IRAs. It has to be kept separate. And if you inherit IRAs from someone else, you can't commingle that unless it's from the same person. There's a lot of rules floating around here. A lot of rules. Yeah.
So you said something a second ago that I wanted to confirm with the question that you. So if two siblings inherit this IRA, can they take different options?
Yes. They will establish separate inherited IRAs with their portion, and one can take a lump sum, and one can take, the lifetime if they want. So it's really up to them. Now, if a trust is involved, it's a different situation, which I'm not going to get into today. I'm talking just regular old designated beneficiary designation. Okay. Question? Yeah, one up front.
Are there tax consequences for rolling your spouse into their IRA?
There's no immediate tax consequence. And remember, you don't pay the tax until you actually receive it. Oh, sorry, the question was, are there any tax consequences for rolling that into your own IRA if you're a surviving spouse? There's no immediate tax consequence, but when you start taking distributions, then you pay tax. That's the thing, going back to is it Sherry, right? Sherry's original question is, who pays the tax and when? It's when you receive those dollars, that's when you pay the tax, okay? You actually receive it. Until then, it's held with the IRA custodian, and it's not technically in your possession. You own it, but it's not taxable to you at that time. Okay? These are really excellent questions. Any more before we go on? All right. So again, we got to go through all these rules. So those were the payout options for designated beneficiaries. Remember, those individuals, still beneficiaries on September 30th of the next year, etc. What about non-designated beneficiaries? These are charities. Let's just use charity as an example. That's something we all understand. You have a few options. You can take the lump sum, which is what most charities are going to do because they don't pay income tax. Why would they let it sit there any longer? They want to put it to good use. They want to put it in their investment portfolio. They want to take it. If the person died before 70 and a half, you can take it 5 years. There's no lifetime. If they died after 70 and a half, you have to take an RMD based on the original owner's life. I don't know, why a charity would do any of these. There may be a circumstance. One just doesn't come to mind. Most charities are going to take the lump sum. Now, let's say we have a situation. Let's move to the next slide here. Multiple beneficiaries, okay? Let's say that I was named beneficiary of my mother's IRA, and on September 30th of the following year, her church is still named as beneficiary along with me. I'm not a designated beneficiary, am I? These are my only options. I'm an individual, but I am still named as a co-beneficiary with a non-entity, a non-human, non-person, okay? So that could be an issue, because maybe I want to take the RMD method over my life expectancy, which I could have done if the charity were not a beneficiary on September 30th of that next year. I know it gets a little confusing. So if both happen, I'm limited to those three options on the previous slide. We don't really want that, do we? How do we get around it? How do we get around that?
Separate IRAs?
Separate accounts, that's a great idea. Just name your family as beneficiary one account, name the charity as beneficiary another account. Any other ideas? Yeah?
Just cash out the charity before it's.
Exactly, and that's what most people will do, is the charity will file their claim form for their portion before September 30th of the following year, so they get their money right away. The family, they're all designated beneficiaries now. Everyone is happy. Everyone's happy. And that's usually, I think, what happens. Has anyone run into this situation before? Okay, you probably get the notice that someone died and you just file your claim form right away and you don't have to worry about this anymore. But sometimes you're not notified of the death for a while. So that could be an issue. But hopefully you have enough time between the death and September 30th of the following year to get that cashed out. Okay? So charity takes their lump sum before September 30th, and then the individuals have all those options that we showed on the designated beneficiary option. The lump sum, the 5 years, the life expectancy, you can decline if it's a surviving spouse, they have those extra 2 options. It's pretty easy. Or just name them on separate accounts. Okay? Questions there? All right. Yeah, we got questions.
If you're the designated beneficiary in the Designation, you are, and you must choose the RMD, you get to the after you have
So the question is, I'm 40, my mother's 85, or my grandma, whoever. They give me their $500,000 IRA, and I choose the RMD method. I choose the life expectancy method. When do I have to start taking distributions? The answer is right away. Okay. I can't delay that until I'm 70 and a half. If I'm inheriting it, I'm a non-spouse, I have to take it right away. Now, if I were a surviving spouse, it's a different story. I can deal with that 70 and a half delay, put it in my own account. Okay, clear? Good questions. All right. I know we went through a lot of kind of technical stuff here this morning. Didn't have a whole lot to do with giving yet, but I think, again, it's important for you to know these things. So when you're having conversations, you're aware of these things, and you think, oh yeah, I remember there's something about that designated beneficiary. I better look that rule up again. It'll trigger it in the back of your mind in the future. Okay, a few best practices. Earlier I mentioned how easy it is for a beneficiary designation to be changed or eliminated. Let's say that account moves from Wells Fargo to US Bank, beneficiary designation is changed for whatever reason. Someone forgets why they made the gift. It's easy to make that change. So keeping the donors engaged is not an easy task, but it is certainly very, very important. Making sure they understand why they made the gift and why they made the gift of this particular asset is very important. That they understand the taxes. And it doesn't have to be very, very complicated. We don't need all these spreadsheets to explain it. I think we just need to understand this is a very tax-advantaged asset. If your family receives it, they're going to pay tax on the entire thing. If they receive a different type of asset, not going to go into those, but there are assets they can receive tax-free at your death. So let's do some good, solid planning. Make sure that donor understands why they made the gift and why they made the gift of this particular asset to make sure that stays in place. The other thing is talk to advisors. You want to make sure that those people who are helping them with their beneficiary designations understand why they made the gift and why they made the gift of this particular asset. Because the financial advisor, the CPA, or the attorney may have some other ideas about why we may want to change this, but it's all about the donor's intent, right? It's about where they want their assets to go and what is the most tax-advantaged asset to give to which beneficiary, right? That's really what it comes down to. So in the planning process, if you're not there to remind the donors and talk to the advisors, changes can happen, and the donor's intent may not be carried out. So keep the donor engaged, talking to them, reminding them, talking to the advisors, keep that line of communication open. And I know sometimes that can be a very tense relationship between you and the advisors because it feels like everyone has a different set of motives. But I think we can all agree it's really about the donor's intent and what's important to them, what they want to accomplish. So it's all about their goals. Keep that as a top priority. Question?
So it definitely stays in touch with the spouse or the children.
Mhm. Yep.
Because when you make these choices, it's in the beneficiary designation process.
Yep.
And usually if maybe this is an IRA holder.
Right. So the point Mary Alice is making is really great. You also want to keep the lines of communication open with the family. Because if, Junior, me, finds out that my mom's $500,000 IRA is not coming to me, it's going to that charity on the street, she's 85 years old. She can't make that decision. She doesn't know what she's doing. Why did you do this? And keeping those lines of communication open and letting them know that, yes, provisions have been made for you and provisions have been made for the charity. This has been a carefully crafted plan. Everyone benefits. So communication is key. We don't operate in a vacuum. Be a part of the donor's team and make sure that we keep, again, their intent and their goals as the top priority always. They have an intent to help your organization. Great. Let's help them make that happen. Okay? Coordinating death claims. This is something I think Cindy and I ran into this problem at InFaith. Filing a death claim form without coordinating, and you're smiling, Beth back here, she knows, without coordinating with the rest of the family can have some interesting consequences. And I'll just put it like this. Let's say that this donor has multiple accounts with a financial company. And the charity gets the notification that someone has passed away, they file their death claim form. That could cause some automatic consequences at the financial institution. Other assets could be automatically paid out to the beneficiaries once they get that first death claim form and a death certificate. The family may not yet be ready to take those assets. So for whatever reason, for planning reasons, for tax reasons, so you want to coordinate with the advisor, the financial advisor, with the attorney, with the CPA, whoever is that advisor, to make sure that they're ready for you to file that. Okay? So just, again, what's kind of the theme of this slide? Keep the lines of communication open. It's better than operating in a vacuum, because it could be some bad consequences. Has anyone ever run into this other than me? Yeah, you have? Okay. Many times. So we want to coordinate the claims, okay? Make sense? The last thing I want to touch on is procedures. Who has specific procedures in your office for death claims? So a few of you have actually seen the procedures. How many have one person in your office who handles, or at least one department that handles those claims? All right, is it the finance office in most cases? Yep, finance office, or is it the development office? Development office, okay. It depends on the organization. I think the finance office can handle it certainly efficiently and effectively, but because I think of kind of donor sensitivity, sometimes these are handled in the development department, but it can be done either side. My advice to you is get some procedures. Get some procedures. If you don't have some, talk to your colleagues, talk to the organization, the PPP, talk to your colleagues and these other great organizations we have. I don't know if the MPCG has advice on procedures, but get some. It's really, really important. Not only because the people in the office need to know what they're doing, but what that person who holds the strings leaves, and you don't know what the procedures are. I don't know what I need to do to file a claim for a life estate reserve. I don't know what to do for, a commercial annuity. What do I do here? So having set procedures, reviewing them often is very, very important. It sounds really boring. Nobody really wants to talk about it. Procedures are a pain in the rear, but they're really, really important to have. I think it's also important, and this is a best practice, have one person or maybe two people in the office who do this. There's a lot of tracking involved. Have I requested the death certificate from the funeral home? Have I requested the claim form from all the different institutions that we're beneficiary of? Have I filed that claim form? There's a lot of different things that go into that tracking. So if you have someone who's kind of on top of that, or maybe two people that are on top of that, it's good. And those procedures can help with that turnover process. Or if there's a question and someone says, this is kind of screwed up, well, I was following the procedures that our institution laid out. So we want to make sure you have proper procedures. Does anyone, and you don't have to tell me what it was, but does anyone recall running into a situation where, procedures probably would have been helpful, or a death claim was dropped, not done properly. Yep. If you haven't run into it before, you probably will. But great procedures, well-written procedures can help you avoid that. Okay? Any questions before we move on from best practices? Main theme, communication. Communication is key with all the necessary parties, the family, the advisors, everyone involved, the donor, first and foremost. Let's move on and talk a little bit about legislation. In the past several years, we've had something called the IRA charitable rollover. Wonderful, wonderful development for charities, for donors, gave them more flexibility to give out of their retirement assets. So I'll just give you the rules as to how it works if you're not familiar with this or you need a refresher. Sherry's question, your question is just perfect. We keep coming back to it. When do you pay the tax? When you take the money out? Well, can I just send my IRA money to charity and not pay tax on it? No. You take possession of it and then you give it to charity. You recognize the tax and then you try to take a deduction. Well, for the last several years, it has been possible for someone 70 and a half or older to direct up to $100,000 right to charity, not to a donor advised fund, not to a gift annuity, right to charity. They don't have to claim it as income. So it's a very special opportunity, and it can count towards the required distribution they have to take for that year, and it's not taxable. So that's a really good opportunity for a lot of people. So up to $100,000 from your traditional IRA, your SEP IRA, your simple IRA. So IRA is not 401ks, not 403bs. That expired at the end of last year. I think Congress extended on December 12th last year for all of 2014. So we didn't have a lot of time to do planning, but a lot of people had made those gifts in anticipation, hoping that that would have been passed, and it was, retroactively for 14. We haven't yet seen anything for 15. We've seen a few efforts to try and make this permanent, which would be fabulous, because then we wouldn't have to be waiting until December 12th every year for this to be passed. You know, it's a benefit for charities, it's a benefit for individuals, it's not really a benefit for tax revenue. Because on $100,000, that could be quite a bit of tax revenue. So that's always the push and pull is, funding. We need that funding, we need that revenue. So this is something we might see in the future. We might see it just extended for 1 more year or 2 more years. We might see it extended permanently, but right now, not available. Show of hands, whose charities received one of these? At least one. Yeah, look at the amount of money that was probably accelerated to charities in the last, 8 years that this has been available, something like that. So it's an incredible opportunity for charities. So we hope that it's extended again. Who in the room has thought about, wouldn't it be great if they could put it in a gift annuity? Think about it. So you take that $100,000, you put it in a gift annuity, it starts paying out, and the donor pays tax on it as it's coming out, right? So it's actually accelerating the tax revenue, right? But they don't ask us, do they? So that'd be a nice thing. But right now it's just straight to charities if they extend it in its former version. Any questions about that? That's a lot of legislative stuff. Questions?
I'm involved with the legislation to expand it and seal it at 500,000.
Oh.
Okay.
Okay. So is that at
Just got a school too.
Okay, great. So Mark has a little bit of an inside lead. Potential extension of this legislation permanent.
No promises.
Okay. We have permanent extension. I'm not testing any of this. This is Mark. Want to talk about it? Talk to Mark. $500,000 would be the ceiling, and you'd be able to do it at 59.5. So we shall see what happens. There's a lot of proposals out there, but we'll see. Any other questions about that before we move on to the next thing? All right. Who in the room read the White House's 2016 budget proposal? I know, bedtime reading, right? This is thick, it's huge. One of the things in that budget proposal is to eliminate the stretch IRA or the lifetime IRA for non-spouses. So let's remember back a few slides. We said that it was relatively new for individuals to be able to take an IRA, an inherited IRA from a non-spouse, and stretch the payments over their lifetime. It has been proposed that that is going to be eliminated. They'd have to take it out lump sum or within 5 years. Those would be the only options. So that's the proposal. Did anyone hear that or read that? Okay, so that's kind of a new thing. We'll see if that happens, but again, it's trying to generate some more tax revenue. There's a little bit of philosophy behind it. This was a retirement asset that was given special tax-deferred tax treatment for that person's retirement. Only for that person, not for their heirs. Maybe for their surviving spouse, yes, but not for their heirs. So there's no reason why they should be able to spread that out over the life expectancy. They should have to get it out of there. Okay? That's kind of the philosophy behind it. You agree or you don't agree, whatever, but that's kind of the reasoning behind it. There's kind of some discussion out there going on about a way that you could potentially get around that if that were to happen. And that, it intersects with charitable giving. The idea is that you would just name the charity as the beneficiary for a gift annuity for that person. Does anybody have any experience with testamentary gift annuities? Yeah, a little bit. Well, if you have any experience with it, they can be kind of complicated. The beneficiary designation has to be very specific, and you tell the personal representative to take this money out and go to the charity and engage in the gift annuity agreement, because you can't have a gift annuity agreement until you have the gift date and you know the rate and when it's actually going to happen. So the actual gift annuity can't be established until after you die, so all those instructions have to go in the beneficiary designation form. It can be kind of complicated, and some forms just aren't long enough, or some companies won't accept them. So that can be kind of an interesting process. Can you think of another alternative that might work? What? Over here? The CRT, the testamentary CRT, we've been doing those forever and ever. So I know I said I wasn't going to go into a lot of techniques, but that might be an option. So if we do see this, testamentary gift annuity is certainly an option. I think the testamentary CRT might be a less, iffy way to do it. So either possible, testamentary CRT might be a better option in a lot of cases. Okay? Questions about that? We actually got some gift planning stuff in here today. Questions, answers, and discussions. Last bit here. We went over a lot of details here. Anything you want me to clarify, questions you have, ideas, thoughts? I won't sing the Jeopardy theme song. No? We got them all out? Oh, okay. I knew if I waited long enough.
Lots of, say, 90% of heirs cash in the IRA when they get
Within 2 years. Yeah, most heirs, and I think I learned this, probably at a U of M Foundation educational event many years ago. The stat really stuck with me, and I think it still rings true, is I think 80% of these retirement accounts are completely cashed out within 2 years. So I worked for 40 years to get that money for my retirement. I pass away, and my kids take it in 2 years and buy a new boat. Maybe they named the boat after me. But yeah, so yeah, I think that statistic still rings true because it's my money, I want it now. It's that whole thing, it's that mentality. I didn't work for it, so I want the money now. Obviously some are good planners, but a lot of people just take it right now. Yeah, you had another question, I think? Yeah.
Probably answered a follow-up meeting, but going back to that issue of whether within the state or not,
Yeah.
and being taxable or not, life insurance, I'm saying it's not taxable in the state out.
Yeah.
So I suppose you have to figure out which vehicle was in the state, which one is the beneficiary.
You're talking about,
Tax.
yeah, right. And so I think really what your question comes down to, the question gets back to what assets go into the estate, what assets go to the beneficiaries directly. One common technique is you give your life insurance to your family, you give your retirement assets to charity, just because of the taxes. Life insurance is tax-free, retirement assets are taxable to the family, but tax-free to charity. So yeah, that's oftentimes the strategy that people will employ. Okay. All right. Oh, we got some more. Okay, one back here.
Why is it a bad idea to put an IRA into a testamentary deed trust?
Why is it a bad idea to put an IRA into a testamentary lead trust? I don't know.
I have an attorney tell me it's bad ideas.
Well, I think it probably depends on the situation. So I wouldn't go there. It may have something to do with the income taxability of the asset, because the lead trust is not a tax-exempt trust, so that could be why. But I'm not positive. All right. How are we on time here? We're going to wrap it up, I think, if we don't have any more questions. We good? Okay. Well, if anybody has any more questions, I will be here. I think we're going to transition to our next speaker, but I want to thank you for your patience and all your great questions. So thank you very much for being here. I hope you learned something today.
I would like to welcome lots of questions. We'd rather have this be a dialogue as opposed to a lecture, but there are some technical aspects where I'm going to have to look at my notes and lecture a little bit to you. I have to say that when it comes to financial planning, thank you, financial planning, estate planning, and charitable planning, planning with retirement benefits, as you can see, it's one of the most complicated areas that we get into. And Dana did a fantastic job of laying out the rules. There's a lot to consider here. It's pretty easy to say, okay, name the charity as the beneficiary of an IRA. But it's everything behind the scenes that we have to deal with to make sure that happens. And we have issues pop up where there are changes, spouses make changes, there are changes in leadership, changes in the relationship, and we want to ensure that that makes it to the charity. Every conversation that we have as an estate planner at our law firm with clients, typically there's an element of charitable planning. As an estate planner, we look at assets. What assets does the client own? Is there a cost basis involved? What's the best type of asset to give a charity during life? Someone tell me? Appreciated assets, right? So low cost basis, high appreciation. That's a gift that we want to give during life. What's the best asset to give at death? Well, at death we get a step up in basis, right? So at death, we look at what assets are taxable, and that's the whole reason we're here today. A tax-deferred account is the perfect, one of the perfect gifts to give to a charity because of the deductions that we can receive. And when I first got into this business, I worked for a firm, and and this is another crass term. We estate planners sometimes use crass terms when we're discussing this, but they refer to tax-deferred accounts as tax bombs. And the reason that is a tax bomb is because at some point in the future, the owner is forced to pay taxes on that. And we know that some point in the future is at age 70 and a half. You can't get around that. You have to start taking a required minimum distribution at that point. Or at death, whoever is named as the beneficiary, they have to start taking a required minimum distribution. If it's the spouse, they can delay it a little bit. If it's a non-spouse as the beneficiary, it's within the year they have to start taking that RMD. So we can't get around that. Today in our presentation, I'll speak first. Jessica's going to jump up a few times here and there while I'm speaking. Then she'll take the second part, and we'll kind of tag on and off. Again, ask questions as we go. I'll talk about naming the spouse as the beneficiary of an IRA and a charity. We'll talk about what happens when you name a trust as the beneficiary of an IRA, because if it hasn't been complicated enough already, it really gets complicated when we run RMD through a trust and onto an individual beneficiary and then ultimately a charity. And then we'll talk about the estate. A lot of times, a rule of thumb that financial planners and even some estate planning lawyers will say is never, never, never name an estate as the beneficiary of an IRA. It's a good rule of thumb, but sometimes there are reasons that you want to do that, and Jessica will cover that. And then we'll talk about different types of charitable trusts and funding those trusts with IRD assets. And we'll do a comparison of the different techniques. Again, ask questions as we're going. And then we'll wrap up with the discussion of best practices, what we do to try to make sure that families understand what mom and dad wanted to have happen with their assets when they pass away. And we'll talk about a common theme that everyone who's gotten up to the podium has discussed today, and that's communication amongst advisors. These gifts don't happen unless all the advisors work together and work with the family to make sure that in the end the gift goes to the right place. So with that, I'm going to start with the most basic technique, and that's having naming the spouse as the beneficiary of the IRA with the charity named as the contingent beneficiary. And the spouse is named as the IRA beneficiary, the designated beneficiary. Remember, to be a designated beneficiary, you have to have a heartbeat. That's the spouse. If the spouse, the deceased spouse has not reached age 70 and a half, the spouse is able to just roll that IRA into her own IRA or his own IRA and start taking the required minimum distribution once they reach age 70 and a half. No taxation takes place until that distribution comes out. They can always take more than the required minimum distribution, but they can't take less. What happens with the charity? The charity does not get its gift until after the surviving spouses die. And what's our challenge here? The challenge is that if the spouse does not have the same feelings about that named charity, he or she can change it, right? Because they become the owner of the account, they control who that charity is. So if you haven't had an opportunity to get to know that spouse beforehand, this is the second chance to get to know them and make sure you build that relationship. When the spouse passes away, then if the charity remains as the designated beneficiary on the IRA, a charitable deduction will be allowed to that person's estate when they've passed away. So there's no tax deduction up front, but once it passes on to charity, then a deduction can be taken at that time. Any questions to this point? That's easy, right? Okay. Another way that we can do planning, and this is better for the charity, is, and Dana mentioned this. Let's say that your donor has $1 million in an IRA, and they love your charity. They want to name your charity as a beneficiary, and they say, okay, $700,000 will be enough for my surviving spouse. They can pull an RMD off of that and live quite nicely with the other assets I've left for them. Let's split the IRA in two. So we set up an account, an IRA that names the surviving spouse as the designated beneficiary, and we name another account. We set up a second IRA naming your charity as the beneficiary. And so when the owner of the IRA passes away, or the IRAs in this case, the spousal IRA passes to that spouse. That spouse is required to take out the required minimum distribution. They pay taxes at the ordinary income tax rate. But you, the charity, received an outright distribution on the second account that named you as the beneficiary. So there's no waiting involved, and in that case, the estate would get a tax deduction, a charitable deduction for that gift that's made. Question?
Just a point of clarification, that splitting account into two IRAs happens during the owner's lifetime?
That would be during the donor's lifetime. So this is a discussion you'd have with them, and this is after a lengthy conversation, and you're able to find out that they feel that there's enough for the surviving spouse, and they're willing to do that. And and it's a hard conversation to have with a donor. I've talked to other development officers who say that, the kids, surviving spouses, they feel like we're asking for this money. We can't wait for the donor to pass away, and that's obviously not true, but we are trying to gather assets and get the assets to our nonprofit. And so, Gary?
Yes, I just would like to make a comment on this. So I've been in that situation a few times, and have recommended this, but in I think all the cases, the financial planner who manages that account has resisted it because they say, it's just a lot more work, there's a better way to do it. And then I know there's some financial planners here, they can comment on it, but there is that, it's not an easy sell. It's a great idea, but it's not an easy sell.
I'm glad you got us to that point, because that is the point. Splitting into two IRAs, everybody wants to consolidate, right? They don't want multiple accounts. So in some situations this might be right, but typically they don't want to go through the headache of setting up another account, filling out more paperwork. And so it's an option, but not always the best option. And as both Jessica and I are talking, if we're talking about a technique and you tried to implement this technique and it's gone well, share with us how it went well and why it went well. If it's gone poorly, that's probably more important. Tell us what happened, what did you learn from it, and how would you do it differently? Yes, question in the back.
I don't know if you already gave that answer, but if I can just name 2 equal beneficiaries of the one IRA.
I'm sorry, can you repeat?
Why can't you just name 2 equal beneficiaries of one IRA?
Okay, so name a charity and a spouse. You can name them both as the primary beneficiaries, but remember, by the end of September of the year following death, we need to make sure that all the beneficiaries of the IRA are individual beneficiaries. So that means they have a heartbeat. A charity does not count as a designated beneficiary. And so what we're able to do is you can name both, and then by the end of September, the charity needs to be paid out. So in my situation, let's say we have $1 million IRA, we do 70% to an individual, 30% to the charity.
We prefer it the other way.
Okay, other way. 70% to the charity, 30% to the individual. Jessica, you were going to
I
add.
have a comment to that too. I'm sorry, something's up in my microphone. I think one of the issues is that, and we run into this as estate planners, the family comes forward and the kids say, you know, mom's now in kind of a compromised state, and we'd like to make sure that her estate plan is in order. Let's review it together, even though we're not your clients. And let's go through all of these beneficiary designations and let's adjust them to match mom's intent or our family's intent. So I think when you have this extra layer of splitting the account during lifetime, there's something that feels different about having this IRA over here that's reserved for charity, and then mom's IRA, whether or not we think it's actually a barrier to them changing these beneficiaries. I think it could be an extra hurdle when in the family's minds, or it could be an extra benefit for the charity for the family to recognize that as a set aside or part of the mom and dad's intent.
Yeah, it's a great counterpoint. If we do split the account in two, you have a charitable bucket, and everybody sees, oh, that was mom's intent. And it's really hard for all the kids to sit down and argue, well, she didn't really want to spread charity. She took the extra step to fill out the paperwork. Yes?
I've not been in this situation, but I would guess that the extent to which you've developed a relationship with the other family members as a nonprofit, the easier to sell.
That's exactly right, and we'll give away our ending, but family meetings. Do you have family meetings with, you meet with the donor, you might take both the donor and their spouse to lunch, but how often do you sit down with the children? And, if there's an opportunity to honor that donor, maybe they've given a lot during life, and you can invite the family to an event, that's really what we all need to do, is build that relationship. This is a relationship business, and it's not just with the donor. It's with all the family members. The family members need to see what your charity means to their parent, and that this is really what they wanted. They wanted to see the gifts made to charity. Other questions or comments?
The Q-tip doesn't give you any deduction up front when you do that.
No, and we'll talk about Q-tips in depth. And really, on all of these, you're not getting any deduction up front until the gift is actually made to the nonprofit. So if I name my spouse as my beneficiary of my IRA, and then I name my favorite nonprofit as the contingent beneficiary, my estate will not get a deduction, a charitable deduction. It won't happen until after my wife Jeannie has passed away. And then her estate, her personal representative, will claim the deduction at that point, once the gift is made. And it works the same way on the Q-tip. So that's splitting an account, splitting the IRA in two separate beneficiaries, charitable bucket, non-charitable bucket. So this is a great segue. The way that we can ensure that a gift actually makes it to your charity is by implementing trusts and naming the trust as the designated beneficiary of the IRA. And Dana went through the designated beneficiary rules. What does qualify as a designated beneficiary, but I'm going to repeat them because this is important to know. And you may or may not be reading trust documents, but I'd like you to just be aware of what the rules are. How can you have a trust and have it qualify as a designated beneficiary, and then see that the assets flow through and get to the proper places? So what's a designated beneficiary? As I said, a designated beneficiary is an individual. Only individuals can be designated beneficiaries. An estate does not qualify as a designated beneficiary. Dana mentioned this. We'll discuss how it can still work, but an estate does not qualify as a designated beneficiary of an IRA. And if a person does name an estate outright and there's no estate plan in place, it's a lump sum distribution, and that's taxation all up front. One of the things I learned early on in this profession was always, 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 always stretch an IRA. And we talked a little bit about the benefits of that in Dana's session, that you can stretch the taxation out for a lifetime, and it's able to grow and grow. And or if someone needs more up front, they can do that. But the best thing to do is stretch it. If you name the estate, you're not always able to stretch. So this brings us to a trust. Is a trust an individual? No. So it's not really a designated beneficiary. But the tax code allows us some maneuvering, and if we comply with certain rules, we're able to see through the trust and look at who the beneficiaries are. And so long as those beneficiaries count as designated beneficiaries, then we have a designated beneficiary by naming a trust as the beneficiary of an IRA. Now, there are 5 requirements in order for a trust to qualify as a see-through trust and to be a designated beneficiary. The first is fairly easy to accomplish. The trust has to be valid under state law. So chances are your donor has worked with an estate planning attorney, and they've created a trust that's valid under state law. The second requirement is that the trust has to be irrevocable at death. Okay? The trust has to be irrevocable at death. So if a person has a revocable trust, would that count as being irrevocable? Not during life, but at death, it becomes irrevocable, right? So you've cleared that hurdle. If the trust is set up under the will, the trust isn't created until after they've died, so you have an irrevocable trust. So that's another pretty easy hurdle to reach over. The third qualification is that the beneficiaries have to be identifiable within the trust. So we have to be able to read the trust document, or the trust under will, and we have to be able to see or determine who the beneficiaries are. It might be my spouse, it might be my children. Who are the beneficiaries? Can we determine that from the trust? The fourth requirement is that certain documentation needs to be provided to the plan administrator if it's a 401k, or to the IRA custodian if it's a standalone IRA. That certain documentation is typically the trust. They need to look at the trust and see that, yeah, this is valid, and there might be other information that they'll need. That needs to be provided to the plan administrator or the custodian by 10/31, the year following death. And then the last requirement is that all the beneficiaries of the trust have to be an individual. Okay? A charity's not an individual, right? I had to go off the question.
So when you say the third requirement, that all the beneficiaries have to be identifiable,
Yes.
does that mean like actual names and persons, or can it be by role?
It could be role or class. So my spouse is the primary beneficiary. My children. Typically in our documents, when we're drafting one of the very first paragraphs of our trust, we define the family, who their family is. My spouse is so-and-so, my children are, or my only living children are, and then we name the children and we give their birthdays. But it could just be my children. I have to admit to you that my estate plan was created before my first child was born. She'll be 14 in April. And my estate plan says it creates a trust for my children. None of my children are named in my trust, but both Paige and Aaron will be taken care of if I pass away and Judy passes away. But the trust will define who that is. It can define a class, and for the purposes of naming a trust as a beneficiary of an IRA, spouse, children, that works. We can identify who those people are. And that's actually what I've done with my IRA and 401k. I've named my wife first, and then my trust is the contingent beneficiary. Okay, so valid under state law, irrevocable upon the death of the IRA owner. Beneficiaries are identifiable under the terms of the document. Documentation to the IRA custodian, and all beneficiaries must be individuals. So the way that we get around that fifth requirement of the individuals being the beneficiaries of the trust is we create what's called a conduit trust, okay? And for purposes of RMD, the required minimum, or the required minimum distribution, and the remainder beneficiary of a conduit trust does not count as a beneficiary, all right? So if the charity is the remainder beneficiary, it doesn't count for purposes of the minimum required distribution, all right? And then all trust beneficiaries, we need that individual rule. Conduit trust, it's not an IRS term. It's a term that's used by practitioners. And the reason it's called a conduit trust is because each time the trust receives a distribution from the IRA, it has to run that RMD like a conduit through the trust and pay it out to the beneficiaries, so it doesn't accumulate. So this is a great technique when you have beneficiaries who can manage money, they're not under a disability. Let's say that you have someone who has special needs. A conduit trust might not be the best vehicle for them because it might disqualify them for certain benefits that they receive, or maybe someone has a spouse or a child who has dependency issues or some type of issue. But in order to qualify as a seeker trust, we've got to run it through the conduit trust and pay out the distribution. So, yes, sir.
Back to that fifth point about beneficiaries having to be people, then, my experience has been very few clients know what type of trust they have. If, for the sake of the argument, there's a charitable beneficiary in that number 5, and there isn't a conduit trust, is it that charity isn't eligible to get those dollars, or does it void the whole trust?
Well, you might be able to solve that problem by seeing if there's a specific gift to the charity, and then taking other assets and liquidating those assets and paying the gift out to the charity.
But for the sake of the argument, if it was a charity listed as the beneficiary of the IRA, what would
If you don't have a conduit trust, it could, well, then it wouldn't qualify as a see-through trust.
Okay, so that still would invalidate the whole trust for that.
For that purpose.
Yeah, for that purpose, okay. Thank you.
You're welcome. Do you have additional,
I just
yeah.
have a comment on that. So this conduit trust issue, what you do is you lose the stretch,
Yes.
right? And then you're forced into a more quicker payout of the account to the trust, and sometimes at a detrimental tax rate, right? Because we know that irrevocable trusts have this really high marginal tax rate. So you gotta make sure you're working with a good tax planner to figure out how that's all gonna sort through. But I wanna jump back to Dana's presentation and just talk really briefly. She made a point that 80% of accounts are distributed out in 2 years. So this isn't as much of a charitable planning comment,
No.
but I wanna say that sometimes when clients come in and talk with me about I'm really concerned that my kids are going to just not think in a tax-wise way about this retirement account. How can we address this in my estate plan? Sometimes we'll set up a conduit trust that will, in essence, force them to take the stretch out, right? Because you name another trustee, they don't have a choice but to accept those RMDs through the trust. And so that's one way to kind of have a little more control from the grave.
Exactly, and that's why I typically advise clients to name the trust as the beneficiary, and we draft conduit language into our documents. And I'll read our language to you later on in the presentation. But also, so Bob, in your scenario, if that were to happen, one of the things we'd want to do right up front, before we get to that December or September 31st point, is make our determination that we're going to take a 5-year distribution rather than all in the first year, so that we can stretch out the taxation. Unless well, I can't see why we wouldn't do it that way. Any other questions? Okay. So we're going to talk about Q-tips. Do you all know what a Q-tip is? A Q-tip, not the kind that we clean our ears out. A Q-tip is, and that's an old joke, sorry. I'll say that. A Q-tip is a qualified terminable interest property trust. And it's a type of trust that's created, or it's an election really, that's made on a marital trust. So when we're doing AB planning with a client, we have a family trust, and that might fill up to the credit amount. So in Minnesota, it's $1.4 million. Everything above and beyond that goes into another bucket. I like to talk about trusts as buckets. The marital bucket. And on the marital bucket, we're able to, or the person representative is able to elect the Q-tip election. And what that does is then the decedent receives, they can pass as many assets as they need to that surviving spouse, and they claim the marital deduction. So no estate taxes owed at the death of the first spouse. And but in order to get that Q-tip election and qualify, the trust has to pay out all income to the surviving spouse. And no one can have any power to appoint any of the principal to anyone else but the surviving spouse. So the surviving spouse can be the only current income beneficiary of that Q-tip trust. And so when you look at those requirements, and then we look at the requirements of a conduit trust or a CFU trust, you see how nicely the requirements all pair up, because you have to pay out the RMD, right, to through the conduit trust and out to the beneficiary. And with a Q-tip trust, you have to pay all the income out to the beneficiary. So we're able to name a Q-tip trust as the beneficiary of an IRA, and then ensure that the RMD gets paid out to that spousal beneficiary. And again, from a taxation standpoint, income tax is paid by the beneficiary. So he pays at his income tax rate, or she pays at her rate. There's no charitable deduction yet because the gift has not been given to charity. And then when the surviving spouse passes away, the IRA gets distributed out to the nonprofit. You have a charitable deduction on the estate tax return if there's an estate tax return due. Again, income tax went to the beneficiary. Now, if we have more than one individual as a beneficiary of a trust, so let's stop talking about Q-tips for a second. We'll talk about if we were to do this with a credit shelter trust. And let's say that we have 4 children as the beneficiary of that credit shelter trust and the surviving spouse. This is where it gets even a little more complicated when you name a trust as the beneficiary of an IRA. Because when you do that, to make the required minimum distribution, we end up having to look at the oldest beneficiary's life expectancy to pull out the RMD. And so if it's the case of a spouse who is older than the children, which often is the case, it's not always the case, we're pulling out the RMD at a faster pace than we normally would. Or let's take a situation where maybe it's a large family and the oldest child is 10 or 15 years older than the youngest child. And we want to make sure there are some IRD assets there for that youngest child. But we have to take an RMD at the oldest child's RMD or life expectancy. And the way to get around that is to create separate trusts. And then the beneficiary of the IRA is each one of those separate trusts. And so then we're able to pull out a stretch based on that person's life expectancy. Okay? This is
Custodian figuring out the life expectancy of the beneficiary?
the custodian is and the trustee, they're working together. So the trustee has to provide this information. And that's part of the documentation that's due up front. So they want to see who the beneficiaries are. They want to see ages. They're looking at the life expectancy, and it's called the uniform table, and making this calculation. So each year, that calculation is made, and a new distribution amount is determined. Okay. Let's see, I've covered.
Jason, could I ask a question, or are you ready for questions?
Go ahead.
On the Q-tip, if the spouse wanted, or the trustee, well, first of all, can the spouse be the trustee of the Q-tip?
The spouse can be the trustee of a Q-tip.
So if the spouse wanted a larger distribution than the required minimum, can they elect to receive an additional amount in a Q-tip trust?
They can.
And so, and also for a credit shelter trust, so unless that conduit language is there in a trust, the beneficiary could always opt for an amount larger than the RMD.
That's correct.
Unless you have that conduit language.
That's correct. Lauren. Other questions? Yes?
Can a charitable remainder trust be a beneficiary of Q-tip?
Jessica, are you covering that in charitable remainder trust?
And we can talk about that. I'm going to talk
Yeah.
about CRTs. I'll think about that before I get up.
Yeah, that's a good question. Other questions? I went through that quickly, and this is a good transition point. So,
Okay, so we're going to transition a little bit away from Q-tips. Now you're all awake again. Just a couple of comments before we jump into looking at charitable remainder trusts. Two resources that Jason and I and a lot of the attorneys in our office regularly use for retirement account planning is Natalie Choate's book. I'm sure you've all heard of it. You've probably heard her speak. But it is sort of the resource to go to. It's a little bit of choose your own adventure, right? You're going through it and you're going back and forth and there's all these references, but if you stick with it, typically you can find your answer in that book. It's just a small. And then Bob Keebler also has a lot of resources that are available publicly just on Google. If you search Bob Keebler and IRA chart, you're going to find this chart that is a very handy, quick reference for you to be able to trace through and see what depending on what your beneficiary designation says, how the IRA rules will work. So that's just a quick note. We go to those resources regularly. So I'd like to just talk about, so our topic is, how do we ensure that the charity has a secure, or relatively secured interest in the gift that the donor intends, right? So we've been talking about these different ways so far to kind of address this issue depending on the donor's interest level in complicated alternatives to just a straight beneficiary designation. So I want to talk about a charitable remainder trust, and many of you, I know many of you in this room, you're familiar with charitable remainder trust, but we're going to talk, for the benefit of those of you who aren't, we're going to talk just about a couple of the basics, and then we'll dive into how you pair a charitable remainder trust with an IRA. And I think the answer to your question, Mark, is you can name the CRT as a beneficiary, but then you're in a land where the spouse has already died. So usually we use this when we have a surviving spouse and we want to run the IRA through the charitable remainder trust for the reasons we'll talk about in a minute. I've never seen that done. I think you probably could. I don't see why you couldn't.
I'm thinking if you have multiple heirs.
Yeah, maybe if you wanted your children to be the beneficiaries of a CRT, I suppose you'd have to go through and think about, okay, what age might they be in? Are they going to meet the tests and what are the terms and so forth? So just to talk about charitable remainder trusts here. This is a diagram that I use regularly, and it's just a picture of how a CRT works. And for those of you who are new to CRTs, sometimes you hear the phrase, my middle name is honesty, right? If you're trying to say, like, it's an attribute of mine. For those of you who are new to charitable trust, I always say the middle name is remainder, and that means the charity is the beneficiary, right, of the remainder of the trust. Similarly with the lead trust, charitable lead trust means the charity receives the lead interest in the trust. So it's an irrevocable trust. That generally means that you can't change it. There are ways to change it, but we generally say if you're setting up a CRT, once it's funded and in motion, it's not, we don't amend it typically. There are exceptions. And it can be for somebody's lifetime. It can be for a term of years. And, there's certain rules under the tax code where you have to comply, so we always like to advise you to work with an attorney to draft this and prepare it, make sure it complies. And here, CRTs can be funded with lots of different types of assets, but here we're talking about funding this type of a trust with an IRA. So what happens is you, the donor, would create a charitable remainder trust in one of two ways. You could either put it in your testamentary estate plan, so it could be a separate article in your will that's actually a charitable remainder trust, and all the terms are there. It could be a separate article in your revocable trust, and for those of you who are just getting to know estate planning, a revocable trust is just a will substitute. So it can act like a will and have the same terms as a will. Or it could be a standalone revocable trust that is a charitable remainder trust. And what you would do is you would name the charitable remainder trust as the primary beneficiary of your IRA, and you would name charity as the contingent beneficiary. So if the spouse survives, the account is paid into the charitable remainder trust, and if the spouse doesn't survive, charity just gets the account outright, and it follows the same rules that we've been talking about up to this point. So what happens when the account goes into the charitable remainder trust? Well, the trust itself doesn't pay income tax, right? So even if there is a realization of income when the account is paid into the trust, the charity itself doesn't realize the income, but as the spouse receives payments over time, those payments would be ordinary income to her over the term of the trust, which might be her lifetime, okay? So the IRA would be included in, say I'm the person that, in my estate, if I'm the IRA owner and I'm leaving it to this charitable remainder trust. So if it's includable in my estate, and I name this charitable remainder trust, the beneficiaries of that trust are my spouse and charity. And so I'm going to get a combination of deductions, a marital deduction for this portion going to my spouse for estate tax purposes, and a charitable deduction for the actuarial value of the remainder that's going to charity. If I instead, like Mark suggested, maybe I don't want to name my spouse, maybe I want my kids to be the beneficiaries, well then you're going to use up some of your estate tax exclusion, right, because it's a gift, and you wouldn't get a marital deduction for that. But that might be okay, maybe you plan it that way. The bottom line is that neither the charity nor the CRT are designated beneficiaries. So here, we aren't concerned about qualifying for a stretch. What we're doing is we're intentionally allowing that account to hit the trust, and magically we get to work underneath the charitable remainder trust rules to create a new type of stretch out, right? The stretch out that's required by nature of the rules for the charitable remainder trust. So I'll pause there. Any questions? Bob. So the question is, can you have the payouts go over multiple generations? Well, I think here now we get into the charitable remainder trust rules. We've left the IRA rules. Yes, we've left the IRA rules, and you can have successive beneficiaries. The trick is going to be, depending on who your successive beneficiaries are, you'll have to determine what your estate tax consequences would be for that. Yeah, and the whole idea with this strategy is that at the end of the trust term, the charity is going to get them whatever's left. And because we have designed it in advance with a certain payout, we believe that there's going to be a remainder and that there's a certain amount that's going to go to charity. And it's not subject to the changes of a financial power of attorney or a child who comes in and has mom change her will or whatever. Practically speaking, this technique, it has some barriers. So I'm going to jump into a couple of other ideas for alternatives to this. So when Gary and I were talking about this presentation a while back, one of the things that we talked about is how doing a charitable remainder trust seems complicated. And it kind of is. I mean, there's some barriers to doing it. It's not as easy as just doing the beneficiary designation. You actually have to hire somebody to walk with you through certain decisions that you would make in setting up the trust. Okay, who's the trustee going to be? What's the payout amount? Deciding the charity in advance. So there's all these decisions that have to be made and a planning process that happens. And sometimes the cost of doing that can be a real barrier and just sort of seem not worth the effort. Well, isn't there an easier way? So let's kind of jump into a couple of other opportunities that could be alternatives to this charitable rollover IRA idea. So I'm broadly going to call this coordinated language, but we're going to go into kind of the nuances of this, and we're going to really kind of dig into this question of what can we do with the estate plan, the will, and the revocable trust? Remember I mentioned that's just a will substitute. What can we do in the estate plan to ensure that the donor's intent around charity is followed? So one thing that we can do is let's assume we talk with the donor and we say, okay, it's your intent to leave this great IRA asset to us. That's wonderful, but we have this issue of depletion. So, okay, it's going to be primarily for your surviving spouse's benefit, and she might live a long time, and by the time she passes away, maybe it's a fraction of what you had hoped it would be in coming to our organization. Well, what we could do is just have some language in the will that would say, it's my intent, I give $100,000 to, EFCA Foundation. And, but the personal representative must reduce that gift by the amount passing to that charity outside of this will by reason of my death. So essentially you create a trigger. So you might not be ultimately using IRD assets for the gift, but you could have that memorialized in your will. Dana talked about how wills often are not changed. I mean, there's more difficult to change. And so what you've done is actually create a memorialization of the donor's intent in their estate plan that if there is $100,000 in their IRA, great, it'll come from that tax-advantaged asset. If not, it'll come through the estate. And one situation you might think of for this, let's say you're meeting with a married couple, they both say, yes, we want $100,000 to go to EFCA Foundation. So they might both have this language be triggered at the surviving spouse's death in their documents. And then let's say that surviving spouse does live quite a while and depletes the asset. Maybe the home is an asset that is sold in the surviving spouse's estate. Okay, well maybe the proceeds from that home could be used to satisfy that gift instead. So just kind of an idea from an estate planning perspective of a way to address this depletion issue.
You don't have to name the asset. You can just name the depletion. So you don't have to designate the house or the second house or whatever.
So the question is, do you have to designate which asset? We're going to get back to that because there's an income tax issue that I want to address related to that question. You could say the house if you wanted. I mean, you could give a specific gift, but we'll talk about what that might look like if you're trying to maximize
the income tax benefit for IRD assets that might be flowing through the estate. Yeah.
And just a comment here too, that you could also use that makeup as a percentage of the estate. So sometimes if you don't want to set a particular dollar amount, you can say, I want 10% of my total estate. So in that way, as your estate becomes more valuable or is depleted, the percentage also changes.
So the comment is you could also, instead of just having a specific dollar amount, say I want 10% of my estate to go to my charity and have that be the offset. And you could also reduce that by the amount passing outside of your will as a result of your death, and that would be in a beneficiary designation asset. Okay. The one caveat there is that you still have the surviving spouse with the ability to change her will, right? So we still have some level of revocability of the gift, but it's another idea that might be the donors might be open to. Okay, so then I want to talk about what happens if you actually name the estate or the revocable trust as the beneficiary of the IRA. And I have to tell you, I've learned quite a bit in looking at this issue for this presentation. And I'm by no means an expert, but I'll tell you what I've learned. And the issue is much trickier than you would anticipate. So here's the general rules. Okay, so the general rule is if the IRA is distributed to the charity before the asset is collected by the estate, then the item, as we've talked about, is included in the charity's gross income. Under 691 of the code, you don't have any actual income tax payable. Okay, so if the estate instead collects the IRA asset and then distributes it to charity, it might, depending on the language in the will, it might be able to take a deduction under 642 of the set-aside rules for estate income taxes. We're talking about the estate income tax return, Form 1041, not the estate tax return, Form 706, okay? So stay with me here. Okay, the IRS has mixed authority as to whether or not you can take that set-aside deduction if your gift to charity is a pecuniary bequest. And I have to pause there because I was telling my husband about this presentation last night. He's a musician, and he said to me, wait a minute, I just fell asleep a little bit during that sentence when you said pecuniary bequest. Okay, so what is a pecuniary bequest? It's really simple. The personal representative must distribute $10,000 to Luther Seminary, right? Okay, that's a pecuniary bequest, right? $10,000, that's pretty easy. So the issue is the IRS has some sort of mixed, they're unclear in their guidance as to whether that is eligible for that 642 set-aside deduction. So the confusion lies in a chief counsel memo that came out in 2006. And I'll just describe to you what the situation was there. There's also other private letter rulings that go to this, and we all know that those rulings are not binding on our particular situation, so you always have to proceed with caution in this area. But the problematic memo came out in 2006, and the facts were that the IRA was left to a trust, a revocable trust, and under the revocable trust, there were 3 different gifts to charity, and they were all pecuniary gifts, right? So $10,000 to my favorite charity. The trustee distributed the IRA in kind to satisfy those pecuniary bequests, and the trustee had the power and the discretion to distribute any asset to satisfy those pecuniary bequests. Well, the IRS said, that's taxable income. That's a realization event. That's taxable income to the estate, and we're not going to let you take that set-aside deduction. And Natalie Choate agrees with this conclusion, because the problem is when you have a pecuniary bequest and it's coupled with discretion, there's this theory that you could have satisfied it with a non-IRD asset, and therefore we're going to treat it as a sale or exchange, and you're going to get taxed. Because that's a problem, right? Because what if your pecuniary bequest is relatively large in relation to the estate, and all of a sudden you trigger all this deferred income tax, and now the family is paying that income tax at a really high rate under the estate, and your charity is getting the specific gift, and they're going to be mad. Okay, so what do you do about it, and what are there alternatives? So then there's two other ways that you can make a charitable gift under your will. One is a specific bequest. I give my IRA to charity, right? So, or the personal representative must distribute these IRD assets to charity. All of a sudden, you've taken away the discretion. So the fiduciary no longer has the discretion to say, okay, I'm going to satisfy it with something else. The IRS says that's okay. We're going to let you take the set-aside deduction for that portion. Another way is by making the charity a residuary beneficiary. So I give 10% of the residue of my estate to charity. The IRS says, yeah, that's okay too. We'll give you the 642 deduction for that. But who knows that? I mean, what client that comes into my office is going to appreciate the difference between a pecuniary bequest and a specific bequest and a residuary bequest, right? So this is why we have all this confusion in this area, because once you get into the actual drafting and looking at their documents, and some attorneys don't use plain language in their documents, and so it's really hard to know what kind of a distribution you have unless you have an attorney that can recognize this issue and interpret the document for you. Stephanie, you had a question. Yeah, so Stephanie's comment is that, one best practice might be just to simply suggest a residue gift. Is that a fair assumption? Okay. Yeah.
How much of the effect is the timing of the distributions? The first one being the IRA to the estate of fiscal year, sometimes that can get confusing.
Yeah, so Mary Alice asks, what about the timing? I think the timing, and again, I'm not an expert in this area, but I think the timing lies in first you'd have to say, okay, the estate is not a designated beneficiary, so what are our rules around taking this income? And then you have to go into this other world of what does the bequest look like under the document, and what are the rights, and then how do we satisfy that? So can we pay the specific bequest right away so that we don't first have income hitting the estate and then a charitable deduction in a year that doesn't match? But again, I think you'd have to work through that case by case. Tom.
I was going to make sure that everybody understood the comment you made about making an in-kind distribution.
Yeah, so Tom's comment is, just to be crystal clear, if you have a specific bequest that binds the personal representative's hands and says you have to distribute this account in kind to this charity, then the income is actually never even hitting the estate. It's going directly through. The IRA will then be cashed out by the charity.
Can it be a percent of the IRA, not the whole thing?
I think so. Gary's question is, could it be a percent of the IRA? I think so. I think you could say 10% of my IRA and then divide it on date of death value. But I don't know the answer for sure. It's also important, there's some language in the document, I'll come back to Harlan. There's also, it's important to have some language in your document that says the fiduciary has the right to satisfy the gift in cash or in kind, right? So there should be a state law power for the fiduciary to satisfy it in kind if it's a specific bequest or a residuary bequest. And then also some language about being able to satisfy gifts non-pro rata. And then Chris Hoyt recommends that you have language in your document that says specific instructions for a fiduciary to satisfy any charitable gifts with IRD assets, and that it's the donor, the testator's intent that the distribution will qualify for 642. I don't know. Maybe that's self-serving language, but that's another recommendation. Harlan.
I think you just answered my question.
Oh.
What Chris Hoyt recommends.
Yeah. Okay. Okay, so all that is just as kind of a footnote on this idea of naming a will or your estate or your trust as a beneficiary. The bottom line is the easiest thing to do is one, make sure you're working with the advisory team that can help you navigate these rules. But also, I mean, there's some really clear, predictable things we know, right? If you split the IRA in two, for example, I mean, we know what the consequences are there. I think when you get into this coordinated language, that's why there's so much misunderstanding around this. Is it's just a really complicated area that's full of a lot of traps. So, okay. This is our chart comparing the methods that we've talked about today, and we can send this to you if you'd like. But essentially what we've done is just say, okay, what are the 5 options that we just talked about today? And here are the different, on the column here on the left-hand side, okay, we know the types of things the donor might care about. Maybe controlling the charitable gift, controlling the amount that goes out to the spouse. Is principal available in a financial emergency? Will the entire account be available for the spouse if she needs it? And when does the gift actually happen? So this just kind of walks through and does a comparison for you of those different options. And you can take your donor's preferences and filter them through this chart. Again, we can send you this chart if you'd like it. Okay, I want to move on because we're kind of closing in on time here. But there's 2 other things that we want to talk about. One is how can we get our clients or our donors to talk to their family about this? We've talked about it a little bit here. And the other is how can you as development staff and representatives of your charity talk with your donors about these options? So the first topic of how do we get our clients or the donors to talk with their family? I mean, this is just kind of a practical solution saying, look, let's make sure that the kids and the spouse usually already knows, but the kids know about the intent here. So one thing that I like to do with clients is to suggest after we've gone through and updated their estate plan to say, what would you think about having a family meeting? And the types and how a family meeting plays out are as unique as there are families. And so sometimes we'll say, well, let's sit down with just your kids and let's do a diagram of your estate with no numbers. Right? That's kind of the least risky first family meeting. And then sometimes they say, well, we want to include our sons and daughters-in-law, or let's go ahead and put numbers in there because they're going to find out eventually. So it just kind of depends on how comfortable the donors are with their family. But I think a family meeting can go a long way in helping the kids to understand what mom and dad's intent is. And oftentimes we will, through my office, kind of facilitate that meeting. Either we'll host it or we'll help create the documentation around it, or we'll even come in and explain how the plan works so that the client doesn't have to remember all of the nuances of their plan, the trust and tax planning in particular. Another thing that we sometimes do is encourage clients to do a family letter, or sometimes it's called an ethical will. It's just intended to communicate some values that aren't always obvious when you read a will or a trust. I mean, usually the kids aren't sitting there poring over the will and trust language. It's pretty dry. And so this is just meant to give the kids an additional layer of here's what we're thinking and here's why we did this the way we did. So I'm going to read to you just a sample family letter. Again, there's no rules around this. It's not binding legally, but I just wanted to kind of give you a flavor of what it might look like. So, for example, dear children, our legal and financial documents might reflect the way we've lived our lives, but they do not provide a clear statement of our family goals and values. We're writing this letter to you, our children, and your families to describe what giving means in our lives. It's our intent that the balance remaining in our IRA is transferred to our Family Donor Advised Fund at Community Foundation at the death of the survivor of us. Our goals for giving through the IRA are to help the helpless, to help the underprivileged, to support culture and the arts, to support medical research, and so on. Because philanthropy is so important in our lives, we'd like to encourage and increase the time and financial commitment of our family and nonprofit organizations that align with our values. We would also like to encourage you to reflect on your own giving of your time, talents, and treasure. Please take your roles as successor advisors on our Donor Advised Fund seriously. Specifically, by this letter, we request that you honor and celebrate our wishes that the remainder of our IRA assets pass to charity. In doing so, we would like to set an example of generosity for you to follow. Love, Mom and Dad. So, and sometimes clients will say, can you draft that for me? Can you give me a starting place? Because they don't necessarily know where to start. But once you kind of put pen to paper, then they like to do a lot of edits. And that's great, because then it's their voice. So have any of you, my question now is, have any of you done this? Have you had donors who write a letter to their kids, or have you had donors who talk about a family meeting? Yes, a few people. Any experience? Yeah.
Well, I just had a question mostly. So with the donor advised fund, you can't donate like your RD to the donor advised fund. That's not, but you can donate the basis after you die to the donor advised fund?
Okay.
Or are you mixing what a donor advised fund is and your state?
Well, I just was picking a charity just as an example, but yeah.
You know, the donor advised fund people set up, I was under the impression you can't transfer IRA assets.
Well, as a beneficiary designation, I think you can name your donor advised fund as a beneficiary when you die.
But not that conduit RMD.
Well, I think you can if you receive. Whoops. If. Oh yeah, you can't do the IRA charitable rollover, the 100,000 that's available. You can't do that to the donor advised fund. But if you take RMD and it's income in your pocket, you can take that income and give it to charity, and a donor advised fund is okay too. And then take a regular charitable deduction under the
Forget about the charitable deduction, but at death, you name your donor advised fund.
Yes. You can name your donor advised fund as the beneficiary of your IRA. Yes. Any other questions, comments? Then the other topic is, how do you, as a representative of your charitable organization, talk with clients about these issues? And Jason and I were talking about this actually yesterday in our office. And we were saying, it's really tricky to raise this issue because, especially in a family where maybe it's kind of your, we'd like to say traditional, but maybe it's just healthy marriage, good relationship with kids. There's no reason to think that the kids would come in and change the beneficiary designation or the spouse would change the plan. So how do you raise you say, thank you for the gift. By the way, I'm really worried this isn't going to stick. How do you raise that with your donors? I think it's really tricky. And maybe if it's a second marriage situation or a blended family, you have more of a footing because it's kind of a natural conversation to say, maybe we want to do a couple extra things here to try to secure this. But I'm curious if any of you have particular thoughts or comments on that discussion. Mary Alice.
Had a number of family meetings where we use usually games because they're kind of non-threatening. We talk about where is it going, what do we want to accomplish.
So Mary Alice said one technique to use might be a game or some type of a discussion around family values and having the family sort through what's important to them as a family and having that conversation. Okay? Yeah. Right. So the comment is if you if you ask some leading questions about the family, how are your kids with money? Or I don't know, maybe that's too intrusive to start with, but maybe, how are your kids doing? What do they do for their careers? Maybe you'll find out that one of them has been through bankruptcy or something comes up and you think, oh, well, maybe there's a way that you could address that. Maybe we need to talk about the possibility that there could, if you have an estranged child or some issue. Maybe I had some clients that I met with this summer where the spouse, it was a couple, the spouse had just gotten diagnosed with Alzheimer's, early stage, but she knew. They came in and they just sort of knew what was coming, what was in front of them. And it was really hard because we had this conversation about what changes should we make to your plan now. And, we talked about, making sure that the kids are named as co-fiduciaries with her, that we didn't actually take her out of those roles in his documents, but we named them as co-fiduciaries with the kids so that the kids would be able to step in. But that type of a thing, if you get a health diagnosis or something, it might be a natural way to say, well, let's talk about ways that we can secure this knowing that you're going to have some period of potential incapacity. Yeah.
Can I just go back to the family letter for a minute? I think that is a great technique because it allows the donor in their own words to say what's important to them, and that's reviewed by the advisor.
That's a good idea. So Tara says it's a good idea to have that family letter reviewed by the advisory team to make sure that it's not inadvertently inconsistent with the plan. And I agree, especially when there's a lot of technical language, and we know that donors and clients might use words that don't really fit with the plan. And so to be able to review that, one thing that I like to do is when I've had clients do this in the past, I'll say, why don't you send me the original of that and we'll put it with your will. And it gives me the opportunity to review it and ask questions of them if I think there's some ambiguities. Yeah. Yeah, so the comment is using, and remind me that Dan Taylor, Creating Your Spiritual Legacy. It's a book, it sounds like, about ethical wills, essentially. You know, one other thing that Jason and I talked about was making sure to invite other advisors, just outside of not only the estate planning attorney, who's clearly going to be integral in some of these techniques, but also involving other advisors whom the client might trust, their accountant, and if they've got a life insurance person or somebody else that they would normally share financial information with, just so that everybody's on the same page, not only the family, but the advisory team. I think that can be really important.
Fiduciary involved, make sure that that fiduciary has a copy of this letter and that they know what the plan is too, and that they're in on this, because a lot of times they don't act until after our clients have passed away, and then they step in. So they need to know what to look forward to and what to circle back and make sure that those details are.
That's a good comment. Jason's comment is make sure to involve if there's a corporate fiduciary, and Jason has experience with working with corporate fiduciaries, but you know, making sure that they're on the same page and they understand what the plan is in advance or at the time that they become a fiduciary. Yeah. Right. So Brad's comment is making sure that you give those beneficiary designation forms to your attorney. You know, that's actually a very, very good point. I can't tell you the number of times I've started working with a family. Maybe their former estate planning attorney has retired and we're working together to review their plan. And I don't see any discussion around beneficiary designations, or at least no follow-up. And so I know in our office, we really make it a priority to make sure not only are we asking about beneficiary designations, but a lot of times we're drafting the language and helping them walk through submitting that, because it can be a challenge, right? If it doesn't fit the 50 characters online. And so we try to help them navigate that. But that's a really good point, making sure we know and understand what the beneficiary designations say, and having that in my file as an estate planning attorney, but then also maybe copies in your files so that you have record of that. Okay, well, I think we can wrap up, and I just thank you all for being so attentive, and I think we have somebody giving closing comments.